And welcome to this week's edition of Yilungelo Lakho, it's your right. Uhlelo kulungisela ke tindzaba texwayiso nako konke lokuthinza ke wena njengemthengi lapha iningizimu Afrika. Mina ke ngisimpiwe Ngqongqolo. Namhla bekunene ke sitawudzingisa indzaba yokuthi ke ungayakha njani imali ngekucashisa indlu noma lekamelo emntini wakho kanye ke nemigoma nemiphandzela yakhona. Now, renting out residential property to tenants is touted as one of the best ways of generating an income. So in these tough economic times, turning your space into cash seems the only way to go. But a rental housing expert advises would-be landlords to tread very carefully before doing so, as a single incident of dispute with a tenant can have very serious financial implications for the landlord.
Because amagama wami yonke into yami ikyala nali lapha kum.
Ayiphelelanga apho uthi lo mqeshi waphula imiqathango ngesivumelwano sokuqeshisa ngokuthi uyemka esenza oko engahlawulanga irente ebilindelwe. Uthi yokugqibela yokuba lo mqeshi umkangelithi uza kubuya ezokulanda ideposit ewayihlala mhla wangena.
This document that we're seeing are the draft regulations.
Waje Chagan kumakhwekhwetho yegqwetha elixazulula ingxaki ezihlela abantu abafana noNomsa. Uthi ukunika umuntu indawo yokuhlala ujonge ingeniso ayonto ilula. Yiyo lonto kufuneka uchule ukunyathela xa uthatha eso sigqibo.
People are under the misapprehension that if a tenant is in default, the tenant has not paid you rental, you can just go and lock a tenant out. Now that is specifically prohibited in terms of the Rental Housing Act. If a tenant is in default and has materially breached the terms of the lease, you have got to make sure that you follow the processes in order to lawfully evict that tenant. Now the bad news is that only a court of law can issue an eviction order.
Kukho ingcamango ithi umthetho waseMzantsi Afrika ukhetha icala xa kukho impixono phakathi komnini indawo nomqeshi. Umzekelo, xa ufuna ukugxotha umqeshi ongafuni ukuhlawula irente okanye waphula imiqathango yezigqibo, iba lidabi elibi elinendleko zamagqwetha nawenkundla yamatyala. Xa inje ayonkcithwe imali na?
That is now, I say, if you go into the business of renting property, you must go into it with your eyes wide open, because the financial implications to you if you have a recalcitrant tenant can be quite devastating. A lot of people have this as an investment. It's a source of income, say, after they retire. Now the tenant doesn't pay and they find that they're in deep trouble with the banks if they've got a mortgage still to pay. And there are huge arrears which eventually they just end up writing off, provided they can just get the tenant to vacate the premises.
Ngelixa ungcolisa ipokodo ukhupha imali uhlalo amagqwetha kunye nenkonzo zikamasipala, akukho nto onokuyenza umqeshi wakho de inkundla inike umyalelo othi makaphume aphele. Ukangwenya uthi akafuni ukuzibona igaxeleka kwimeko enjalo. Yiyo loo nto engangxamelanga kufuna omnye umntu ukuqesha kwakhe.
No. For now, I'm not in a hurry. I just want to relax my mind. Ndicinge ningene endlini ndibone ukuthi ndiyenzani. Ndihlanganise cause kaloku ndinalo ityala lifanele nilibhatale. So ndihlanganise kahle ka ingqondweni yami ukuthi ndifunani, is it worth it ukuthi ubize umuntu.
Ingaba banindawo landlord ngolasemzini banawo na amalungelo alingana namalungelo axhanyulwa ngabaqeshi. Xa inkali exingetyeni afumene kanjani lo malungelo? Kuvuyisela mdoda, Yilungelo Lakho.
Kukhuluma kamatike ngendzaba yethu ke sesimukele ke Michelle Dickens lumelele ke i-Tenant Profile Networks phindze sibe na RJ Chagan lobuya eGauteng Rental Housing Tribunal. A very good afternoon to you. Thank you so much for joining us. Welcome to the show.
Thanks, Simpiwe.
Mr. Ajay, a very good afternoon to you too. Thank you so much for joining us. We'll be coming to you in just a moment. But Michelle, first of all, we've been listening to this insert. I want us to get deeper into the conversation of whether our rental housing laws here in South Africa are skewed in terms of favouring the tenant in this particular instance.
I think the rental housing laws in South Africa are very fair in terms of the fact that both tenant and landlord have access to the rental housing tribunal. It's a free process where both tenant and landlord can go and dispute instances of non-payment, of withholding of deposits, of non-maintenance of property, of the property, etc. But when it comes to non-payment and the tenant sits in the property without paying, unfortunately the Rental Housing Tribunal doesn't have the teeth to evict, as the insert said, and therein lies the problem. And so the landlord then has to spend money to get into the courts. There's a delay in actually accessing the courts, and it costs 30,000 Rand to get an eviction order on average in South Africa. And that amount of money, that cash flow that the landlord doesn't have, is often prohibitive in them then being able to access the law. So the law is there. It's whether or not the landlord can access the law because it costs so much money.
Mr. Chagan, let me also bring you into this conversation. What do you make of what Michelle has just said? Do you think that South African rental housing laws here in the country are fair? Do you think that they favour one party over the other?
It's a beautiful loaded question if you ask if something is fair or not fair. Because if you ask a tenant, the tenant will always tell you, well, it's not fair to me. If you ask the landlord, he'll tell you it's not fair to him. The fact of the matter is in South Africa, to evict a tenant, it's not just a simple question of approaching a court and evicting a tenant. One has got to understand it from our historical context, where our population suffered
Okay, Mr. Chagan, unfortunately, we're having great difficulty in hearing you because the line is not the best. But I'm going to ask my colleagues to establish connection with you from a much more clearer and a different line. We'll be coming to you shortly, so please be on standby. Now, Michelle, I want us to also to get further into the conversation of, what should landlords or potential landlords do in terms of welcoming or before welcoming people into their homes?
So, Simpiwe, I think what's really, really important is that both private landlords, which make up 70% of the rental housing in South Africa, as well as estate agents, which make up the other 30%, both have access to the same quality of services to protect themselves in terms of selecting a tenant, getting the right lease agreement in place, and then managing their tenant right throughout the lease process. So starting at the process of wanting to do a screening on your tenant to assess whether or not this tenant is a quality tenant applicant, TPN is the first place to go and look for that, because we'll look at where they've rented, where the tenants rented in the past, how they pay their rent on a monthly basis. So it's not just a snapshot of what the tenant looks like now, it's a 5-year history of the journey that they've been on in rental property, as well as what other credit they've got open. And this is important because affordability is based on what is the income of the tenant and what are the other expenses and commitments that they have. And therefore, we can then deduce whether or not the rental that they're applying for is something that they can afford or not.
Okay.
It doesn't have to be expensive. So landlords would have access to this without, they could create an account on TPN. It's a free service to create an account. There's no monthly commitment. The tenant is only, the landlord is only paying for the credit check at the time that they need to
How much
test.
do they pay to the TPN?
It's around about 100 Rand.
100 bucks?
It's around about 100
once
Rand.
off?
Once off to
Okay.
check your tenant out.
Okay.
And now you know that you've secured yourself a tenant who has not got a history of non-payment, who has a history of paying their rent in the past.
So you basically do the vetting on behalf on the landlord's behalf?
Correct. The landlord will create an account, log into the TPN website, and they'll be able to do a check on their tenant applicant. But that's not where it starts and ends, because this is a relationship that you can have for a minimum of 12 months, hopefully 24 months with your tenant. That's the average a tenant's going to stay in a property. And so what you want to do is you want to do a lease agreement with your tenant. Now, in South Africa, we don't have to have a written lease agreement. Verbal lease agreements are sufficient. But you know, when you have a dispute and it's a he said, she said argument, it's better to have a written document.
Yeah, I mean, it leads to my question, because one may argue that if I'm a private individual and I own a private property and, I haven't registered my property and the rental income to SARS, perhaps. So why should I abide by South Africa's rental laws?
Well, you don't have to register your lease agreement with any database. TPN is a voluntary database that you can register with. Once you've registered your lease with TPN, we'll then manage the tenant's credit profile, and that'll update positively for the tenant. They can build a positive credit profile. You do have to pay your tax to SARS on your income that you have made, your profit that you've made. So you would have to then register with SARS in terms of your tax obligations. In terms of your legal requirements, rentals are still governed and regulated through the Rental Housing Act. So the Rental Housing Act applies to all lease agreements, whether you're renting in a formal, through a formal estate agent, whether you're renting through a landlord who has buildings in the inner city and they have 1,000 leases and you're just one of 1,000, or whether you're renting from somebody with a single room in their property that you're renting just the room from them. The Rental Housing Act is going to apply to all those tenants and all those landlords in the same way.
Okay. So does the law also apply in terms of eviction? If I haven't abided by the South African rental laws and I'm just doing things privately and I've had, you know, an informal gentleman's agreement with my tenant and then the tenant does not pay, so what do I do? Do I lock them in or out?
So locking in or out is absolutely illegal. So the Rental Housing Act will govern your relationship with your tenant.
Okay.
When it comes to evicting your tenant, then we've got to look to the PI Act, Prevention of Illegal Eviction.
Okay.
And here, again, there's going to be a set of regulations that has to be followed before you can evict your tenant. So, for example, a landlord whose tenant's not paying, the first thing that you want to do is put your tenant in breach and demand payment from your tenant.
Yes.
And here, if you have a fixed-term lease agreement, as most landlords do, they have a 12-month fixed-term lease agreement that they've entered into. Now we bring the Consumer Protection Act into this relationship as well. In that, we now need to give our tenant 20 business days notice of intention to cancel the lease should the tenant not pay.
Okay.
If you're on a month-to-month lease, different. Here you can be governed by your lease agreement, and now it's important that you have a written lease agreement, which you can now say, well, if you don't pay the rent, we can give you 7 days notice, and then we can cancel the lease agreement. So it's important to understand what type of lease agreement you want to enter into, month-to-month arrangements, or into a 12-month agreement, but both of those best to be done in writing so that when you want to apply your 7-day notice period or your 20 business days in terms of the Consumer Protection Act, you're backed by your lease agreement, your written documentation.
Okay, all right, let's leave it there, Michelle. We'll continue our discussion in a moment. Bukela sisibambe khona lapho ke sisishiyele ngasetolo. Please do stay with us. Leli Yilungelo Lakho. Welcome back. Sakumola futhi mbukele tincingo tethu sethuvuliwe ukuthi ke nawe ungavakalisa umbono wakho. Sishayele ngelicingo ke ku-011-714-6918 noma ke 011-714-6919. Ungasithumela futhi ne-email ku-consumer@sabc.co.za. Ungasithola futhi na ku-Facebook. If you just joined us, namhla ke sikhuluma ke nge-rental income. Nekuthi ke yini kumele ukuthi ukwende, the do's and the don'ts before you lease out your room or your house or your home to third parties. Nekuthi ke yini kumele ukuthi ukwende, yini ke imithetho kumele ukuthi uyilandzele kuze kuthi ke ungathi so senkingeni yema cost ke lo ngakawabudgeteli noma ke songena enkingeni yekuthi ke kumele ubhadale ama cost ngendzaba yekuthi ke ima client noma ke tenant ayisafuni ukubhadala. Today we have Michelle Dickens from the property network, and as well as RJ Chagan on the line. He's an attorney and a rental housing expert, and we welcome him back. Mr. RJ, a very good afternoon to you. Thank you so much for joining us. We had lost you there earlier. Please do indicate if you can hear me clearly now.
Yes, I can hear you. Thank you so much.
Okay, great stuff. Now, I want us to take us back. I want you to take us back a bit to how you view South African property and rental laws, because some think and feel that it's unfair and they favor one party over the other.
Well, I mean, it's quite true that in order to obtain an eviction order, a landlord has got to jump through many hoops, as it were. It's not as easy as it was in our pre-constitution days, where one could simply bring an application to court and get an eviction order. And of course, this has to be seen in the historical context, where people were arbitrarily deprived of their homes in years gone by. So the provisions of the Constitution have made it very clear that nobody can be arbitrarily deprived of their home. And if somebody is going to be evicted and their immovable property taken away from them, then there are certain judicial oversight processes that needs to be followed. Now, if one has to follow all these processes, and the best well-known is the PI Act, then it does become a lengthy and expensive process for a landlord to follow. But we're not unique in this situation in the rest of the world. In lots of countries, especially in the developed world, in the so-called first world countries, tenants are also afforded a wide measure of protection in order to guard against arbitrary evictions.
So how do the courts view a situation where a tenant is not ostensibly able to pay rent and arrears, but is able to afford a lawyer to block an eviction or a possible eviction perhaps?
Well, a court will look at that question specifically. What the court will look at is whether it's just and equitable in the circumstances to order the eviction of somebody. In order for a court to determine whether it's just and equitable, all the circumstances pertaining to that individual's personal circumstances has to be brought to the court's attention. So how many people live in the house, whether it's a child-headed household, whether it's headed by a woman, whether there are disabled people living there, whether there are elderly people living there, what are the possibilities of finding alternate accommodation that is suitable. All of those factors has to be brought to a court's attention. And then when a court considers all of that, and if a court is satisfied that it's just and equitable, then the court will, in those circumstances, grant an eviction order. But a landlord should not despair. This does not mean that courts will never grant an eviction order. It simply means that the due process of the law has to be followed, and if courts are then satisfied that everything has been done by the private landlord in order to mitigate or to motivate his claim for eviction, then an eviction order will be granted. The difficulty, though, is in the time it takes to grant to obtain that eviction order and the cost of obtaining that eviction order. I heard earlier on Michelle mention it was 30,000 rands. But once you consider the costs of the sheriff and maybe you consider the cost of the red ends, if there's got to be a forcible eviction, then it can easily be double that amount.
I mean, how do we avoid evictions? Because, I mean, if I can't afford paying that 30,000 rand, because that is money that I'm trying to make through renting out my property in the first place.
Well, that is exactly the difficulty in which many landlords find themselves. So people then opt. One of the unfortunate consequences of this onerous legislation is that people will then are tempted to take the law into their own hands. People will lock out errant tenants, which is definitely unlawful. The best suggestion, though, is for tenants and landlords to negotiate with each other when they find themselves in positions of difficulty. The COVID crisis that we are going through now is a classic example of this. There are many people out there who are not paying because they just simply cannot afford to, not because they don't want to. And tenants and landlords should then negotiate with each other honestly and in good faith in order to see if a suitable compromise can be reached. Tenants must always remember that the property does not belong to them, and it's a two-way contractual relationship. In order for them to have a roof over their head, they must pay the rental. And the landlord must bear in mind that in order to do justice to the tenant, he cannot arbitrarily take the law into his or her own hands and has got to follow due process.
Now, one may argue, RJ, that if I did not go through all the processes of leasing and renting out, I just entered into a verbal and a gentleman's agreement with a particular tenant, and that tenant decides not to pay their rent. So one may argue then, if I kick the tenant out, how does that make it illegal? Because the process has been informal from the very start.
Well, it's not a new principle in our law that you cannot take the law into your own hands. It's something that we call spoliation. If a landlord alleges that a tenant is not paying rental, the tenant might have a valid reason for not doing so. The tenant might say, well, I had an agreement with you that if I repaired a certain thing, there would be a reduction in the rental. Or he might say that I had a rebate of 3 months for some or other reason. Or he might simply say that I have paid you and you're just not reflecting the payments. There's always two sides to a story. For a landlord to simply allege that, oh, you've not paid me and therefore I'm going to lock you out is not doing justice. In our law, we have a concept called audi alterum partem, which simply means that both parties must be heard. That is why if there's a dispute between people in any contractual relationship, whether it's landlord, tenant, or any other contractual relationship, Due process must be followed. The matter must be brought to court when an independent judicial officer will then make a decision on the matter. And that is simply a essential element of our jurisprudence, particularly in a constitutional era where we live in a constitutional democracy and we are all urged to abide by the rule of law.
All right, Mr. Chagan, please stay on the line. We'll certainly continue with this conversation in a moment. Now, Michelle, before we get to the whole process of eviction, let's first start by vetting that particular tenant. How do we go about selecting the right occupant? I mean, just during that break off camera, we were discussing that the most important thing is to get the right tenant. How do I know which tenant is the right tenant?
So, I mean, the simplest way of solving a future problem is to select the best quality tenant for the property at the moment. But not just selecting the best quality tenant for the property at the moment, but managing that tenant through the credit bureau rather than, and that's a motivation and an influencing factor that Big Brother Bureau can hold with the landlord to influence the tenant to pay their rent on time and in full. So what TPN does is we've noted that 8 in 10 tenants are actually quality tenants. When it gets to tenants that are as delinquent as a tenant that you need to evict, we're only talking about 1% of the tenant population. So what we're referring to is these very highly delinquent tenants that require an eviction order. We're really only talking about 1% of the population. So what TPN does is we create a credit profile or a tenant profile on every single tenant. And our landlords can simply come into the TPN website. They can register themselves, pop in the ID number, name and surname of the tenant, and request their credit profile. Of course, they need the tenant's consent to do this. So you can't just go and credit check anybody randomly. You need the consent of the consumer to do that check. And that's going to give you a history of how they've rented in the past and what other credit they've got access to.
You know, just to interrupt you there, Michelle, I do beg your pardon. I mean, a tenant may argue that it's not really fair for a landlord to go through their credit profile if paying rent is not a credit arrangement.
It's an excellent question, because there's many arrangements that consumers have that are not credit arrangements, and yet the information is recorded on a credit bureau. So I'm going to give you some examples. Your insurance that you pay, not a credit arrangement, and yet you're going to be credit vetted up front prior to that application. Your telcos, your cell phone accounts, those type of arrangements, not credit agreements, and yet the bureaus will store this information on you. Because affordability is not simply looking at the income of the consumer and then giving them access to a service. It's looking at what other expenses they have to ensure that they're not overextended. So the income is there, but there may be other expenses that the tenant or consumer has that prohibits them from an affordability perspective from being able to pay the rent on a monthly basis. In addition to that, what the credit bureau does is it records how the account is paid on a monthly basis, whether that's your car finance, your home loan, your cellular account, your insurance. Your rent is another one of those. So is the rent paid in full and on time? The TPN Credit Bureau then SMSs the tenant to thank them for the payment and to advise them that their credit profile has been positively updated. This is a fabulous way for those 8 in 10 tenants that do pay their rent to build a positive credit profile that can motivate when they're ready to go and become a first-time home buyer. Now they've got a profile that says, well, you know what, 30% of my income is being used to pay my rent, and I'd like to motivate for my first mortgage bond to be able to enter the home ownership market. And that's a really powerful tool for a tenant.
It certainly is. It certainly is. Okay, let's leave it there, Michelle. We'll be continuing our conversation in a moment. Yilungelo Lakho. Welcome back. Kumbula ukuthi incingo solo tivuliwe ukuthi ungasishayela icingo ke ku 0117146918 noma ke 0117146919. You can email your views to consumer@sabc.co.za or interact with us on our Facebook page. Namhla ke sikhuluma ke ukuthi ke uma ngabe ufuna kwemukela ticashi emntini wakho noma ke ku backroom yakho yini ekumele ukwende. Yini ke indzaba lekumele usike uticacise kuqala ungakamngenisi ngoba phela lokumcoka ukuthi ungenisa umuntu lomatiko ne credit history yakhe lo yatiko nekuthi umuntu lobhadala kanjani ngoba phela kumkhipha hey It's a very, very costly exercise. Njengoba sesimvile Michelle asitshela ngabo 30,000 lapha lekumele ukuthi uyikhiphe kuphume bo eviction order ngoba phela akukho emthethweni bekunene ukuthi utawukhipha umuntu incwazi ingekho lesemthethweni. So that's what we're focusing on today. So what are some of the risks associated with leasing out your home or your room to tenants? Namhla ke sina Michelle Dickens from the Property Network, kanye ke na RJ Chagan from the Gauteng he's a rental housing expert. So we will take your calls in just a moment. But Michelle, I want us to continue our conversation with regards to selecting. Now that you have the tenant in your room, so what do? Do I enter into a lease agreement? Do I enter into a verbal agreement? What then happens?
So TPN absolutely recommends entering into a written lease agreement, and this does not have to be costly. Some people think that because it's a written lease agreement, it's going to be a costly exercise. TPN has on our website lease agreements that our landlords are able to download. They're 350 Rand, and that gives you access to lease agreements for multiple uses, however many times you want to use them. But we also keep them up to date. So when the law changes, when we've got these new draft regulations for the Rental Housing Act, when those change and become law, then we will update those lease agreements as well. So a written lease agreement is really important. Then maintaining the tenant's credit profile, their rental profile on the bureau is also important. We spoke about the 8 out of 10 who are getting those positive updates. Just as important to update the positive information on the majority of tenants as it is to update those tenants who are partially paid or not paid. Because this is your first course of action where you have the Big Brother Bureau looking after, standing behind you to support you when your tenant is not paying. And the SMS that will go out to the tenant is, the Bureau has been notified of your partial or non-payment and your credit profile has been adversely affected. Again, the majority of consumers do want to keep their credit profiles healthy because they want to go and access credit in the marketplace. And it's not necessarily housing that they want to access. It could be other short-term loans, personal loans, credit card loans, vehicle finance loans that they're wanting to access. And so they need to keep their credit profiles in check. Then, of course, the bureaus can help with sending out letter of demands. Again, as a landlord, you don't want to be sending out your own letter of demand. You want the Big Brother standing behind you so that the tenant knows that you've got support. It's not just you on your own as a landlord trying to collect the rent. And so TPN Credit Bureau will send out the letter of demand for the tenant. And this is important because the next step, of course, is loading a default listing. And a default listing now can be loaded on multiple bureaus, not just the TPN Bureau. And this listing will sit for a period of 12 months until the tenant comes and settles, at which point the information will be removed from their credit profile. Now, all of these services that we've spoken about, sending out the SMSs to the tenant notifying of their payment profile, this is a free service. A letter of demand is 55 Rand, it's not expensive. And the loading of the default is a free service.
So who then dispenses the information to the credit bureaus? Does TPN track tenant activity?
Exactly. So TPN is the bureau in this instance. And we partner with TransUnion. So there's multiple bureaus that are being reported on in terms of the information of how the tenant is behaving. And so the landlord actually has the backing of the formal economy in terms of the credit bureau. They're not left in the fact that they feel informal because they're renting out the backyard or they're renting out the back room and it's a verbal lease agreement, not a written lease agreement. They may feel like they're part of the informal economy, but they're not. We're bringing them into the formal economy.
All right. Mr. Chagan, let me also bring you in. When we started the show, you seem to be of the view that South Africa's rental laws are actually fair. I mean, that's very much repugnant to what people have been saying, that South Africa's laws actually protect the tenant. So what are the remedies that are at landlords' disposal should a dispute arise?
All right. Before we go into that, may I just add that in terms of the regulations, which were the new draft regulations, which were published in the Government Gazette just on Friday, just a few days ago, it's now going to be compulsory to enter into written lease agreements. So the days of verbal lease agreements are going to be coming to an end very soon. All right. Coming to the question now as to whether it's fair or not. You know, ultimately this is a matter of perspective. No landlord is going to be happy with an errant tenant, with a tenant that does not pay, and then he feels that his hands are tied and that he actually cannot take proactive measures. But the law is very clear in this regard. This access to services like utilities, your lights, your electricity, your water, other essential services, the fact that you are entitled to have undisturbed use of your dwelling, those laws are sacrosanct. And landlords have to know that if they're going to enter into this arena of letting property, that it comes with risks. It's an occupational hazard. That if you're going to let your property out, you've got to accept or prepare for the possibility that you are going to have errant tenants. Michelle has already indicated that it's a minuscule proportion of tenants who actually don't pay. So one has got to, in one's arrangements, factor into that you're going to have a certain percentage of tenants who are going to be problematic. Do your credit background checks. Take a healthy deposit, a 2-month deposit, if you can, maybe even more if you have to stagger the deposits. Put proactive measures in place in order to ensure that your damage is mitigated. Another thing that landlords forget is that immediately the tenant falls into arrears, take proactive steps and approach the rental tribunal. Don't wait for 2, 3, 4 months to pass, by which time the rental has ballooned to 50, 60,000 rands, and then approach the rental tribunal. Yeah. The rental tribunal is there for this specific reason. Aside from granting eviction orders, which is still the prerogative of our courts, the rental tribunal can assist landlords with non-payment of rental, with damages caused to the property, and all other matters incidental to a landlord-tenant relationship. So the first thing you do is you be proactive, make sure you take a healthy deposit, make sure you keep a BDI on the tenant and see that he's conforming to all his obligations. The minute the tenant falls into arrear, please approach the rental housing tribunal. The service is free, it doesn't cost you a cent, as opposed to approaching an attorney, which can be where the legal costs can be quite prohibitive. And then make sure that you're on top of the game every step of the way. If you do that, and if the tenant sees that you're treating him in a fair and honest manner, then you'd be able to have a much smoother ride than if you just allow things to escalate and get out of hand.
What if the lease agreement, does not state the use of utilities such as electricity and water? If that lease agreement was either verbal or in black and white, what if it doesn't indicate whether the tenants has got access to those utilities?
No, it's a fundamental part of the occupation of a residential property that you have access to utilities. If I buy a car, I don't have to say that the car will come with 4 tires. It's expected that my car will come with 4 tires. If I'm renting a residential property, it's expected that I'm going to have services or access to utilities, to electricity, to water, maybe depending on the area in which I live, to refuse removal, sewer facilities, that sort of thing. That comes standard, and the tenant is entitled to expect those services when he enters into a lease agreement. The lease agreement does not have to state you will have water. What it will state is whether the charges for the utility are in addition to the basic rental or are inclusive of the basic rental.
Okay.
Landlords, as far as you can, please try and ensure that you have prepaid meters for electricity so that you are not left saddled with the bill at the end of the day. One of the unfortunate consequences is that the property owner is always left with the utility account from the municipality. So
okay. Please hold your thought, Mr. Chagan. We need to take a break now. Please hold your thought. We'll continue this conversation in a moment. Please don't go away. We'll be right back after this break. Sakamula futhi mbukele ke kuba ingcenye lenkulumo yethu ke ngasishada licingo lapha e-studio ku-011-714-6918 noma ke 011-714-6919. Our email address is consumer@sabc.co.za. Ungaphinde usithole futhi na ku-Facebook kanye ke na ku-Twitter. If you've got any questions or you want to share your story of your experiences with us, please take the phone and call the number on your screens or that email address on your screens. 011-714-6918 is the number to call. Namhla ke sina Michelle Dickens kanye ke na Now, IJ Chagan from the Gauteng Rental Housing Tribunal. Now, Michelle, now that the tenant is already occupying the property, what if a breach of contract occurs? What's the remedy available to the landlord?
So simply where you want to put your tenant in breach as quickly as possible by issuing a letter of demand. And there's a number of different breaches. The tenant may have noise disturbance. Yeah. There's a number of different breaches. But let's talk specifically around the non-payment of rent and or utilities and or water and refuse removal, etc., because it doesn't just have to be around rental. Whatever the tenant, the total statement account has been delivered to the tenant and they fail to pay in full, the tenant is in breach on day 2. So if the rent is due on the 1st of the month, by the 2nd of the month, the tenant is in breach. And the landlord can at that point immediately issue a letter of demand. In fact, should immediately issue a letter of demand, demanding payment of rent or reminding the tenant that there could be a cancellation, that the landlord would cancel the lease in the event that they fail to pay, that the landlord may come and load default information on the credit bureaus. It's important that that is placed on record and in writing, because the landlord can't take the step of loading a default against the tenant if they haven't been notified in writing. So on day 2, the landlord can take those steps immediately to put the tenant in breach and demand payments. Okay, so how do we avoid an eviction order, because it comes at a hefty price, I'm made to understand, and you know, something that the landlords can't even afford, because the rental income perhaps is no way a match to the 30,000 rand that's required. Right, absolutely. And in fact, what AJ said earlier on is the earlier that the landlord acts to put the tenant in breach, cancel the lease and demand that the tenant vacates, the better. Waiting for the account to balloon in AJ's amount of 30, 40, 50,000 rand, because we haven't as landlords acted soon enough, we're only acting in the 3rd or the 4th month, prejudices not just the landlord but also the tenant, because the more the tenant falls behind, the more difficult it is for the tenant to get back out into the market and find alternative accommodation. So it's best for all parties that the landlord puts the tenant in breach as early as possible. You've got to wait 20 business days before you can cancel the lease. So the letter of demand is step number 1. 20 business days later, if the tenant hasn't failed and settled their account in full, that's when the lease is cancelled. Again, by placing that in writing, cancelling the lease and demanding that the tenant vacate. And you can demand that the tenant vacate immediately at this point. Should the tenant then fail to vacate at that point, then you have a tenant who's now an illegal occupier of the premises. In other words, they should no longer be legally occupying. And at this point, it's time to engage with attorneys to start the eviction process. But up until then, you can kind of take the process into your own hands. Right, right. Now, Mr. Chagan, I've posed this question to Michelle earlier with regards to the credit, the credit bureaus. So is it fair for the landlord to start tracking the information from the credit bureaus, because paying rent is not a credit arrangement?
Hello?
Mr. Chagan, can you hear me?
Yes, I can hear you. I'm sorry.
Okay. Okay, so one landlord may argue that, one tenant may argue that it's very unfair for a landlord to start tracking their information or their credit profile from the credit bureaus, because they may argue that a rental is not a credit arrangement. What do you make of that?
Yeah, there's merit in that argument, but as much as the tenant is entitled to his rights of privacy, the landlord is entitled to make sure that he has a tenant who's not an adverse credit risk. So it is a trade-off that you take when you enter into a lease agreement with somebody, because the landlord needs comfort that the tenant that's going to be occupying his premises is going to be able to meet his obligations. If a tenant stays there and does not meet his obligations, the ultimate risk and the costs of the tenant's occupation fall squarely on the landlord's shoulders. So the tenant must accept that that it's a necessary requirement from the part of the landlord to try and mitigate his losses and to try and minimize any risk exposure that he might have.
All right, let's leave it there for now. We'll take a quick break and we'll be back with more in a moment. Yilungelo Lakho. Welcome to our very final segment. Before we get into our conversation, let's take our first caller. We've got Anonymous from right here in Johannesburg. Anonymous, good evening. Good afternoon. Okay, we seem to have lost Anonymous here. Now, Michelle, I want us to talk about what tenants want from a particular property. I mean, there's certain desires that they may communicate with the landlord in terms of proximity to basic amenities. So what is it that they need before they start choosing or selecting a property to rent?
So I think this is so important from a landlord perspective. If landlords know what the tenant desires, they can set themselves up for properties that support what the tenants need and therefore are less likely to have tenants that are non-performing tenants.
Okay.
So what tenants are looking for at the moment, and it's the same that it's been for the last 3 years that TPN has run the survey, price is still very, very important. Tenants remain price sensitive. And so we've seen that there haven't been high rental increases. These escalations have been low for a very long time. Again, landlords need to be aware of the fact that they're not able to go to market with these 10% increases that they may have experienced in the past. The second most important thing is security. So tenants remain really prioritized on how secure is the premises, on the area that they're renting. And so security is factor number 2 that tenants look for. And the third most important thing that tenants look for is travel time and distance between their work, the schools. For our middle-aged tenants, schools are important, and how far is it to the schools. And for our older tenants, they're looking at the shopping centres. So how far is it to get to the entertainment of the shopping centres. And I think if landlords know what tenants are looking for, they're better placed to make sure that their properties provide that, and that often leads to less disputes with the tenants, which then leads to less non-payment of rent.
And I've realized a trend in the past few years that tenants also do not want an area that has traffic congestion, perhaps. Yeah, not at all. All right, Mr. Chagan, we'll be with you in just a moment, but for now, let's take a caller. We've got Anonymous, is now back on the line. Anonymous, very good afternoon to you.
Hello.
Go for it, sir. What's on your mind? Welcome to the show.
Thanks, man. Thanks for having me. Just a quick question.
Yeah.
I'm a rental, right? I'm staying in the one section of the house. My landlord's brother staying at the back, right?
Say that again,
so
sir.
What happens here now is I'm paying the rent.
Okay.
I'm paying water, I'm paying the light. I'm cleaning the garden. So what happened is his brother left the tap open. His brother's not all there. He's a bit, you know.
The landlord's brother, you mean?
Open, the place flooded. Then he wanted me to pay that amount of money. Then the geyser burst. It took me 4 days to fix the geyser. It was leaking. And I just want to find out who is liable for that cost.
Okay, Anonymous, thank you so much for calling us. Thanks for your time. Michelle, do you want to answer that? He's basically saying that he's renting a house and one of the landlord's brothers left the tap open and he was left to foot the bill, and the geyser burst as well and was also left to foot the bill.
That seems very, very unfortunate, and one that should go straight into the Rental Housing Tribunal, because the dispute there would be who's going to pay this extraordinary high bill for water, and who's responsible to repair the geyser. The geyser would be something that the landlord would have to repair, and that would be an insurance claim through the landlord. But the footing of the bill for the extraordinary high water costs, this is something that should, if the landlord's not prepared to come to the party and negotiate on a fair price, this is something that the Rental Housing Tribunal is primed to respond to.
Right, right. And Mr. Chagan, I guess it falls squarely on your door. In terms of these kinds of dispute, how would you resolve this dispute? We've just had an anonymous caller saying that the landlord left the tap open and he was left to foot the bill.
Well, one must always bear in mind that our law is very clear on what is your liability insofar as the utilities are concerned. You're only liable for what you consume. So as a tenant, you are entitled to see the water bill that reflects your consumption. That is all you are responsible to pay. If there's another tenant in the co-tenanted building that has caused damage and has caused an excessive utility account, which cannot be attributed to you, then you are not liable to pay that amount. And any action that the landlord institutes to force you to pay that amount is an unfair practice, and the Rental Housing Tribunal will definitely be able to deal and to assist with a matter of that nature.
All right, please share tips on what landlords and tenants should do before embarking on an arrangement or a lease agreement, perhaps.
All right. When parties enter into lease agreement, of course, one of the essential elements of the agreement is that the parties must be clearly identified. So the tenant must know exactly who his landlord is, that his landlord has got proper title or has got a proper right in law to lease the property to him. The landlord must know who the tenant is. He must get all the personal information that he can from the tenant. The tenant must agree that the landlord can do a background check so that the parties know exactly who the other party is. Then fundamentally, of course, is the property that is being leased. That must be properly identified. So if it is a unit in a block of
Mr.
flats...
Chagan, unfortunately, time is really not at our side. Thank you so much for taking your time to join us this afternoon, and we'd love to thank you too, Michelle. Thank you so much for joining us this afternoon. It's been a great pleasure chatting to you. Hayi ke mbukeli sesifika kanjalo kumaphethelweni ehlelo lethu namhla ngisibonga ivakashi lethu ngesikhathi labasiphe sona ke namhla ngithandabuka kanye nani ke babukeli ngekuba nathi kuze kube manje asihlangane futhi ngesikhathi lesitako lapho ke sitabe sinilethela khona lolunge indzaba lethinza wena njengemthengi. For me Simphiwe Ngcongwane and the rest of the team sisike nihlale kahle till we meet again. To have a great week ahead. Cheers.
Yilungelo Lakho.